We have several 1030s. Any order that you've established?
Judge, not yet. If Mr. Walsh, is he still here? Mr. Walsh? Judge, I just want to report to you, we provided him with those notices from the 1030 or the 930 call.
Okay.
We still owe to him the publication notices and the actual letter notice, pre-sale notice that SRI prepares. We have to get that from them.
Okay.
I've got an email into them. I've got his mailing address, so I'm going to mail them those two documents, just so you're aware. Judge.
All right, we'll just, Mr. Walsh, we're just confirming for the record that you've provided most of the documents that you had requested from the auditor's office, correct?
Yes, Your Honor.
And there are, what's...
The newspaper publication notices for all three parcels and the actual pre-sale one-page letter for all three parcels will provide to him by mail at his address, which he's provided to me at 4305 Jerry Street in Gary, Indiana.
Okay.
Do you have an estimate how long it will take?
Usually we get it within 7 days from SRI. She'll have it in about a week. Your Honor, on the 1030 call.
I do know that I have one status that was added yesterday, the JLJ Development Co. Attorney Botcher on that. Did you get?
Yeah, I got it late yesterday afternoon, Your Honor.
Yeah, it just came up to my chambers late morning, and I saw your name on it.
No, I appreciate it.
I knew you were going to be here.
Yeah.
So
They're both here, Judge, if you want to.
Yeah, let's go ahead and do that. I just set it for status since everybody was going to be here, and anyway, what can anybody enlighten me on what this is about or what we need to do?
Your Honor, Joe Scott now serving as local counsel for the Anderson Partners LLC out of Indianapolis, Indiana. Due to the short notice, they wanted us to come in and at least be here for the status conference this morning. Your Honor, we filed
You represent who?
We represent, as local counsel, we represent Anderson Partners LLC, who then in turn represents Stephen Mays.
Oh, okay, Stephen Mays, right, okay. And Attorney Brotz, you have?
Tax sale petitioner, JLJ.
Okay.
Development Company.
Sorry, go ahead.
Your Honor, evidently a verified emergency petition to set aside a tax deed has been filed by attorneys for Stephen Mays. Your Honor, evidently there was the property was bought on tax sale. The taxes have never been paid on the property. A tax deed has never been issued. And Your Honor, Stephen Mays is registered owner of the property. There is a economic development project going on in the city of Gary right now that this property is concerning. This is creating a slander on Mr. Mays' title, and Your Honor, we'd like to get in front of you to have the tax deed set aside as quickly as possible.
Attorney Brotz, what can you tell me about it?
I can tell you I received a copy of this late yesterday afternoon. I was fortunate enough to find my file. It wasn't in storage. I haven't had a chance to sit down with my clients. I can't report to the court what their position is because I don't know.
Right.
So I would ask you to set some discovery dates, pre-trial date.
What's the? I know it's an emergency motion. What's the time frame that? I mean, why is it emergency and why is
Your
it?
Honor,
Are you saying there's a need for an expedited scheduling?
there is a need for an expedited schedule. Mr. Mays needs to have this encumbrance on his property lifted so that the city of Gary can move forward with the economic development project they have going on in the city right now.
Where is this parcel? Is this?
Your Honor, it's at 520 Broadway, next to the Gary Bank building down in Gary, Indiana.
In looking at the motion, it doesn't appear to be too complicated of an issue to Attorney Bratz, would you agree with that, or?
Yeah, I would agree, Judge. They're saying, well, they didn't get notice they got sent green cards for Stephen May, so I don't think it'll be a big, long hearing. I
Okay.
think we could get ready pretty fast.
How about March 20th?
Your Honor, what time?
10 a.m., or do you want to do March 13th? You're here anyway, Attorney Bratz.
Let's do the 20th, Judge. That'll be fine.
Is that okay?
That's fine, Your Honor.
And I guess since we have an expedited date, if I need some discovery or something, I'm sure Mr. Sweatnoff will provide it.
Well, I'm serving as local counsel. I'll be certain to get you in contact with with Maine counsel, who's out of the Anderson law firm.
Because I may send some interrogatories and requests for production.
Okay.
That doesn't give much.
Yeah,
That's the only thing.
let your client, let your principal know that, if we're going to move forward on the 20th, everybody will have to exchange things in advance of
Everybody will have
that.
to cooperate fully.
Right,
Certainly, Your Honor.
right.
No problem at all.
Okay.
March 20th, what time, Judge?
10 a.m.?
That's good.
Yes. Very good. All right. Very good. As far as the other 1030s go, are there any cases that there are agreements on?
There is, Judge, on the bottom of page 1 of the call, Mr. Bratz and Attorney Emerson have reached an agreement, and I think that order's already been submitted.
That's true, Your Honor.
If you want to look in that file, Judge, all I saw was the motion that all three parts.
Which one is it? I'm sorry.
It is unexpected returns versus Gilda Cruz on the bottom of page 1.
Oh, yeah.
There should be an agreed order in the file already.
I remember some of these, I think. The last thing in the file is parties report agreement, but no.
I filed a petition, Judge, to withdraw the petition for tax deed and to allow a redemption.
Do you know when you filed that?
February 21st.
Oh, okay. Well, that hasn't caught up with the file.
I can take a copy out of my file if you'd like me to. I've got a copy of the order. That way, at least we know it gets done, and she can approach. That way, Ms. Cruz can redeem, and then know if the auditor's office has been approved by the court.
All right, we'll wait for the rest of the paperwork to come up.
And I have court minutes as well.
Okay. Thank you.
Here for Schuster. Now, 1 second. That'll be quick, isn't it?
Okay.
All right. Anything else on that one?
No, Your Honor.
All right. So as far as the other ones on the 1030 call, there are no agreements. Is that what I'm hearing?
I have a no-show, Your Honor.
That's helpful.
Your Honor, also on the first item, Mr. Schuster, Mr. Bratz is here for him. They just need a trial date on that first item.
Okay. Wittering LLC versus Skyanne Ensign. Ms. Ensign, here? Aren't we set for trial today?
I wasn't quite sure, Judge. What is
They all of them today should be.
the trial? Okay.
Oh, no, it's set for status. Skyanne Ensign?
Judge, she was made aware of this court date. She was in court last time.
She was.
We'd ask that, I don't know if the court would entertain a motion for the deed for her failure to show up for...
I normally would, but this is one where it predates the minutes that indicate that, so
Okay. We ask for a trial date then, Judge.
March 20th at 10 a.m.
That should be good. I'll check with Attorney Schuster. If there's a problem, I'll notify the court as soon as I get back. I do have minutes for that one, Judge.
Thank you. Attorney Polk?
Yes, Your Honor.
This is Carl Spackler LLC versus Michael Shea. Michael Shea. 45-12-15-126-003.000-030. Attorney Polk appears on behalf of Carl Spackler LLC. Mr. Shea fails to appear. We set for bench trial.
Yes, Your Honor.
Are you ready to proceed?
Yes, Your Honor. I can present evidence, or, in the absence of, or his failure to appear, I'd request the issuance of tax deed. He was aware of the trial date at the status conference in December. He appeared in person. This is the file petition. I would reference the file petition as Exhibit 1. It has a copy of the tax sale certificate. It has Exhibit B would be the title work. Exhibit C would be the 4.5 notice and 4.5 certified mail receipts. I have 4.6 certified mail receipts I can enter as evidence if you'd like, along with USPS track and confirm notifications showing delivery to Mr. Shea. But I'll note that at the status conference, Mr. Shea admitted to getting notice. His issue was something with code of Town of Maryville that I'm not sure exactly.
What status conference are you referring to?
It was the pre-trial in December, where Mr. Shea appeared.
November?
It might have been November. Yeah, I think it was November 7th, actually.
November 4th.
4th, sorry.
Okay. Yeah, if you want to submit your evidence, go ahead and submit it. That way we have it in the file showing. Attorney Wiley, any objection?
No objection, Judge.
Submitting as a group exhibit, Your Honor, all the previously mentioned items.
Okay.
Mr. Wiley had a copy.
We'll show the petition is granted. Have you filed a...
Order for use on file.
There is.
Great.
All right.
Thank you very much, Your Honor.
Yep. right, we have 4 more matters. Attorney Kavachkov, how long?
Very brief evidence, Your Honor.
All right. Harriet Howard. Is Harriet Howard here? Oh, Attorney Drake.
Mr. Drake is here representing Paul Howard, Your Honor.
All right. Attorney Drake appears on behalf of Paul Howard.
That's true, Joe.
Attorney Kavachkov for CGS Reynolds. Attorney key number 45-08-10-016-017.000-004. Attorney Kavachkov.
Your Honor, I previously, pursuant to the court's order, sent all of the notices and other elements of discovery that the court had ordered to Attorney Drake. Discussed the matter with him, and he's agreed to allow us to submit to the court the various items of evidence as a group exhibit. Those items would be the tax sale certificate, the title report, the 4.5 letters to Harriet Howard and Harriet Lee, the green card for the 4.5 letter sent to Harriet Howard, signed by Paul Howard, green card for the 4.5 letter sent to Harriet Lee, signed by Paul Howard, proof of publication of the 4.5 notice, 4.6 letter sent to Harriet Howard, Harriet Lee, and Paul Howard in care of Attorney Drake, the green card for the 4.6 letter sent to all 3 parties, again signed by Paul Howard, and a Jan Carnan out of Mr. Drake's office, and a proof of publication of the 4.6 notice. We've now moved, Your Honor, for admission of Petitioner's Group Exhibit 1 with those items.
Any objection?
No objection.
Group Exhibit 1 of the petitioners admitted.
Your Honor.
Yes, you may. Do you have any other evidence or?
No, Your Honor. No other argument.
Attorney Drake?
That's correct. Judge, we don't oppose or challenge the 4.5, 4.6 notices. We don't have any evidence ourselves.
Attorney Drake, could you speak closer to the mic? My court reporter's not picking you up.
Yes. Judge, we don't oppose or attack the 4.5 and 4.6 notices. And we have no further evidence. Mr. Howard is actually in Alaska and working on some other project, and he has we worked out an arrangement whereby he may try and lease the property. So we don't oppose the objection to Attorney Kavachkov's proposal.
Attorney Wiley, do you have any objection?
No objection, Judge. Well, is he saying he has no objection to the tax deed being issued?
That's what I heard.
Yeah, that's what I heard. And we have no objection to issuing the tax deed either, Judge.
Okay. Petitions granted. Attorney Kavachkov, have you filed?
We have, but we pulled the order, so we'll bring a order.
Petition granted, order to be filed within 14 days.
Thank you, Your Honor.
Okay, very good. Let's see. Is Attorney Lewis still here? Right. Might grab them. I'll take Attorney Bratz. You got a couple of them?
Yes, I do.
All right. Bounce on up here. How long are they going to take?
One will take a little bit of time.
How about yours?
Depending on your rulings, it could go very quickly or take a little bit of time.
There was a motion for continuance on that one, Your Honor.
And an objection.
Judge, I have no objection. I've got 2. They've got one they were here before me, so it's
right.
okay to take time.
Gratefully accept.
All right, we're on the record in 45 CO1 1207 MI 118 concerning parcel number 45-07-022-481-021.000-004, Gerardo Contreras versus City Equities LLC et al. Attorney Megan Craig and Attorney John Craig appear on behalf of, by the way, Craig, and Barack. Which one, who's first?
I nominate her.
Depends on what the issue is, Judge. If it's money owed, I'd like to see my partner.
Attorney Megan Craig appears with her associate, Attorney John.
Common question these days.
Attorney Wiley is here on behalf of the Lake County Auditor's Office with his representative, Gina Scheidt. Attorney Lewis is here with his client, Mr. Harper.
Yes.
You, Mr. Harper?
Yes.
And City Equities LLC.
For the record, my client, Mr. Contreras, is here. He's in the back.
Okay, Mr. Contreras also is here.
And then there are also witnesses that are ready to proceed with the bench trial.
All right, now, somebody indicated there was a continuance request filed. I don't see one. Was there, when was that filed, or was it?
Judge, I sent it in, I think maybe Monday or Friday.
Okay, well, it just hasn't.
I never received it, Judge. The reason I thought there was one was because I got served upon me by the Craig Law Firm an objection to a continuance. So
Well, I see an objection to a continuance. I don't see a motion to continue.
Judge, what we received was a CCS that says that Mr. Lewis appears and moves to continue, and that's why it's an objection to a continuance and not a response, because from our perspective, it wasn't a true motion. This didn't conform with the trial rules, so we filed it as an objection because my client has taken off work to be here today. We have a process server who has taken off work to be here today. We're ready to proceed. This has been before you twice before. The discovery cutoff was previously set and has expired. We're ready to proceed. We believe that notices were properly given and a deed should be issued.
Well, Judge, that's yet to be decided. I've been in this case for less than 30 days. I have very little information, very little knowledge about it. I recognize that things have occurred prior to my getting involved, but the fact of the matter is I now represent Mr. Harper, and I know very little about this case. Absolutely little to nothing. And I would hope that in view of that fact, my client would have the right to pursue with counsel who has been adequately prepared. And we pray upon the court to grant our motion to continue.
And as I said, Judge, we have people who have taken off work to be here today. As this court is well aware, a self-represented person, and as outlined in my objection, is held to the same standard as an attorney. You advised him when he was here before that if he wanted to obtain counsel, that he would have he should do that. Waiting until the last minute and on the eve of trial is inappropriate at best. Filing a motion to continue within 10 days is in violation of the trial rules, barring some sort of an emergency. None of those issues have been outlined for the court. It requires an affidavit explaining exactly what needs to be done. I think that this is a delay tactic that is just going to cause my client to incur more costs. We followed the trial rules. We followed what we're required to do to be here today, and to allow for them to come before you the week of trial and say, well, now we got a lawyer, and well, we haven't looked into it at all, and we don't know, and there might be some defenses we don't know, let's just reset it, is an unfair prejudice to my client who is diligently worked forward to try to get this case concluded.
And as I look at this, I don't know how her client will be prejudiced, Judge. Whether we go forward with it today or whether we go forward with it in 30 or 60 days. The same evidence that she's going to present then is what I believe she's prepared to present now.
Unless he's offering to pay for my client's missed work today and to pay for the process server who's shown up today to testify. And there are actual sunk costs that we're incurring by being...
Well, what's the process server's, what's the anticipated testimony?
$75.
$75 is what he charged.
What's the anticipated testimony of the process
He's
server?
going to testify that he went to the property, that he served the property, he placed a notice on the property of the 4.5 and the 4.6 notice.
Attorney Lewis, are you and your client prepared to stipulate to that so the process server is not needed at the next hearing? Take a moment to confer with your client.
Yeah. Judge, if we knew what door he was talking about, we perhaps can. I don't know what door he would testify.
They won't stipulate what happened.
Well, no, he's here, right?
Yeah.
Yes.
Where is he?
Nathan?
Stand up, sir. What's your name?
Nathan Goodall.
Do you recall what door you posted the notice on?
Yes.
Which one?
All signed.
What are you asking for? Front, back, side?
All front.
Front door? Okay.
And the address, that's what we're...
What was the address?
Got a copy of his.
Okay.
Yeah, but he serves, he's...
I understand. Yeah. Let him look at
I
it.
remember this house.
You can tell why he remembers
Yeah,
this
you can.
particular house.
I can tell you where it's at. This house is right across the street. It's a lot. It's got a chain link fence, probably 3 or 4 lots wide across the street from this house. A couple houses down, there's a little old lady who lives in the house. She's probably in her 90s. When I posted this house, she came out and asked me what I was doing, which happens a lot. People want to know what I'm doing. So, I remember.
What's the address?
850 Stevenson Street. It's if I remember correctly, it's a dead-end street. And this particular house is probably 4 or 5 houses down from the... I believe it's a dead end street. Well, only that, but I'm pretty sure it's a dead end street.
Attorney Lewis?
Judge, we can't stipulate. I'm sorry. The property that he...
Well, that's fine. I mean, I guess if I'm going to indulge the continuance, then just so you know, most likely I'm going to hold your client responsible for paying him to come back a second time. That's why I'm trying to...
I understand, Judge.
Okay? So with that, here's the thing with these. I have a lot of these cases. I can't have everyone coming in asking for a continuance on a day like today because that would throw my docket into complete chaos. On the other hand, I feel like I also have to balance the fact that I do put a rather aggressive schedule on these. We're talking about a constitutional right here in property. So this court does not take these cases lightly at all when someone's going to lose their property. There's competing interests in as far as trying to get these things done in an expeditious manner. Prolonging these does no one any good. It doesn't do the tax sale certificate purchaser any good, and it doesn't do the landowner any good. So in trying to balance all of those things, when someone prepares for court like they were supposed to and did, I don't want to penalize them because they did everything they were supposed to do and reward someone who's not doing what they're supposed to do. You understand?
I understand.
So I'm trying to strike a balance between all of those competing interests. Because I certainly, if somebody's going to lose their property, want to give them a full and fair opportunity to present their side of the story. But it doesn't come without pitfalls, one of which is they're here. They're ready to go. They've done everything that I asked them to do, including have this gentleman here. So if he has to come again, you're going to have to pay for it. Understood?
You understand that? Yeah. He understands, Judge.
Also, I have in front of me, which makes it a little more problematic, a motion to bar witnesses. Do you understand that?
Judge,
And I guess there were requests for admissions.
Judge, I, based upon what counsel has indicated to me, I do understand she's filed. That was done prior to my involvement. I do intend to correct, if at all possible, or address those concerns in writing with counsel.
How quickly can you do that?
Probably within the next 2 weeks.
March 20th at 9:30.
I'm going to request as a part of my continuing objections going forward, that if no defenses are raised to the actual notice that we are given, that this court considers sanctions for this continuance, because we believe this is frivolous and just a way for the property owner to continue owning it for additional time. Because we have certified notice, and it's a rental property that we're getting every...
Well, you also, at this point in time, have admissions to every element of your claim.
So I guess that's our request at this point, is we believe that we have a solid case, and that this is going to be a very difficult case to overcome based on the notices, the actual notice that we have to present to the court. I've got clients who are going to be very upset with the fact that they've taken off work to be here today.
I understand, and unfortunately, and for them, my explanation, I hope they may not agree with it, but at least they understand that, this court deals with these cases all the time, and when someone stands to lose their property, that's not something the court takes lightly whatsoever. And as everyone knows, I do put these cases on a fairly aggressive track. They don't linger and languish. We get them in, get a first pretrial, set some discovery cutoff dates, and let everybody know what the rules are and that they're required to play by them. So, I'll give you a brief continuance to see what you can do, but, well, I'll do it. I'm reluctant
I understand, Judge.
to essentially penalize someone that did everything that they were supposed to do and reward somebody that didn't do what they were supposed to do. But because this is a situation where somebody's going to potentially lose their property, I feel that that's necessary. And the briefness of the continuance,
Yeah, 9:30.
we're talking
9:30, you said?
3 weeks, huh?
You said 9:30.
9:30,
What day, Judge?
March 20th.
March 20th, 9:30, when we come back.
What day of the week is that?
That's a Thursday.
Can we include as a part of the order that the respondent is to bring a check from the amount of $75 for the process server?
Yes.
There's also the lost work, and I'd have to talk to my client as what his lost time is, and the fact that I've had my assistant sitting here ready to testify.
I'll consider those on the 20th, but as far as the process server, for sure. You'll need to bring a check for $75 payable to Mr. Goodfellow?
Excuse me, Your Honor, can I give him cash now?
Sure.
Accept cash, don't you?
Cash is okay, isn't it?
Would you like me to prepare a draft order, Judge? I also have a minute sheet that I can prepare.
Yes, please. And you'll
The
file
minute
that
sheet will
with
just reflect who's here, and then I will prepare the order and have it submitted within 10 days.
Yes. Okay, very good.
Settle out this case.
We can't talk about that.
All right,
Thank you, Judge.
March 20th.
March 20th, Judge.
Yep.
9:30?
Yes, yep. Mhm. Attorney Bratz? Which one's first?
I think there's somebody here,
Leslie and Brandy Frazier?
and then also we have, who else?
Okay, well, we'll do this one first. Inwish LLC versus Brandy and Leslie Frazier, 45 CO1, 1207 MI 118, concerning key number 45-08-28-301-009.000-004. Attorney Bratz appears on behalf of the petitioner. Attorney Wiley's here for the Lake County Auditor's Office with his assistant, with his representative, Ms. Scheidt. You are Leslie Frazier? Okay, and you're Brandy?
Yes.
Okay. And we're set for trial, bench trial on your objection. Are we ready to proceed?
Yes, we are, Your Honor.
Okay, go ahead.
No, we're not. We did not receive, Your Honor, as of yet, the opposing party has not tendered us the discovery. Without it, we were not able to provide our own defense.
Okay.
Still, we have a notice saying that discovery is due by January 31st. We have not received not one letter or anything.
It said discovery by that date, Judge. There was no discovery request tendered to my office. I have no idea. There was been no request for discovery, so I have nothing to respond to.
You were here for the 9:30, but apparently, while I try to be very clear on everything, I guess it's a work in progress, and I guess I'll respond to this particular issue that has now arisen today that's never arisen in the past, is apparently some of the folks that have been here assume that discovery means you're going to send them stuff. And not what it really means is that if you want something, you have to ask for it.
Likewise, I've received nothing from them, Your Honor.
Right. So I guess in the future, I will be clear as to that. So what I'm hearing is you're asking for a continuance to complete discovery.
Yes, sir.
Okay. what do you want from Attorney Bratz? Do you have a list of things, or are you just wanting his exhibits that he's intending to introduce at the next hearing?
It's been tendered, Judge, they have it. I just tendered it to them.
Okay.
Exhibits for today.
Okay. All right. So discovery has been tendered. Is there anything else that you...
We will be required to send, response to this.
Judge, I'm not asking for any discovery response. I'm not asking for any discovery from them at this point.
Okay. April 22nd at 1:30.
1:30?
Yes. You're going to be here in the morning, Attorney Bratz, but there's a bunch in the morning. I don't know.
We have a...
Unless you can tell me that some of these, do you want to look at what they are?
I think it has a number of them with Craig, so I anticipate it'll be a busy morning. Yeah. We have a different day, Judge.
Okay, sure.
I think we're going to be using a lot of time on those if it doesn't resolve.
April 24th at 9:30.
That's good.
Attorney Wiley?
That's fine, Judge.
And you're Mr. and Mrs. Frazier? Yes. Can you give me your phone number? 08. That's okay. I'll quick.
Thank you.
Okay, I'll give you a call.
524 LLC versus Hiram Sprouse and Connie Catania?
Judge, I have court minutes with us.
Good morning, I'm Connie Catania.
Good morning. 45, concerning key number 45-15-251-103-251-004.000-041. Attorney Bratz appears on behalf of 524 LLC. Connie Catania appears, self-represented. Are we ready to proceed?
We are, Your Honor.
Ms. Catania?
Last time I was in court, they said that all the documents were sent to my parents' house. This is my mom and dad's property. I did talk to the state of sale office. They said that the letter that they tried sending was undeliverable to the address. The address is correct, so we were never notified in what I feel enough time to take care of the situation. By the time I found out...
Okay, well, hold on 1 second. So, you're saying you're ready to proceed today? That sounds to me like an argument.
Right. I mean, I don't know what else we're supposed to do. As far as the last people, I thought we were going to get discovered saying, what was sent, how they were notified. I never received anything as well. I assumed that it was going to be mailed to my parents' house. So
you assume, I'm not following. You assumed the discovery was going to be mailed to your parents' house, or you assumed
that the discovery
that the
was sent.
4.5 and 4.6 notices were going to be sent there?
Whatever information they said that how my parents were notified.
Okay.
I thought it was going to be sent, so I would have some kind of plan on how I'm supposed to tell my parents.
All right. Do you have it to give to her right now?
Yeah.
And we'll reset it to 4/24/14 at 9:30, and I will be much more specific next time, and
No, I'm so sorry. Can you give me that date again?
April 24th at 9:30. And I suppose in my minutes, I should, when we set the bench trials, just order reciprocal discovery be done. Well, at least order that.
Judge, I asked any exhibits that she plans on introducing
Well, absolutely.
to me prior to that.
That could be the new minute sheet, Your Honor, should say that the parties should exchange, when they're self-represented, when there's a self-represented involved, that...
Just so there's no confusion.
Mutual exchange of trial exhibits.
Within 10 days.
10 days prior to
Well,
trial.
probably within 10, after the pretrial conference, I may just say that they have to exchange within 14 days. Is that too quick?
No, I don't think so.
I mean, if I say 10 days before the hearing, then someone's going to show up and say, I didn't get in the mail until yesterday, and I didn't have a chance to see an attorney, and...
I mean, I have my stuff ready ahead of time, so it's not a problem if somebody asks for it, they get it immediately, so I think that'd be fine.
Okay. April 24th, 2014 at 9:30.
9:30?
Are you intending to submit any documentation or exhibits?
I mean, basically, the only information that I have is that when they tried notifying us, my family, parents, I don't understand why a certified mail would come back undeliverable to the address that they are trying to take from my parents.
Okay, yeah, well, I mean, those are all, is there anything that, if there are any documents that you think you're going to ask the court to look at?
No,
Then make sure you get them to Attorney Bratz
he's right down the street, so
well in advance,
yeah, I can take care of that.
okay?
424 at 9:30?
Correct.
Thank you very much.
And you have minutes for this one, too? All right, there are other folks in the courtroom. It appears to me like we've dealt with every issue on the call for this morning. Is anybody else here in the courtroom that thinks they have a case set this morning? Ma'am? Yeah, what's your name? Do you know, I don't see, do you have a key number or anything that would, are you here for a tax sale case? No. What are you here for?
Child support.
Okay, you're over there, you're down the hall. Who told you to come here?
Downstairs.
Yeah, no. You're over there.
At the end of the hall, it's a family court.
You're down at the end of the hallway. Sir?
Just visiting.
Oh, okay.
Retired.
Well, you are more than welcome. More than welcome. It's a public courtroom. Did you enjoy yourself?
Yes.
Okay, very good.
I
Yes.
might take up this lawyer's